Welcome back. As you've seen, this is the 12 o'clock session on the duty of care in environmental authorizations. I'm going to try and share my screen now. Can I do that?
I think you should be able to, if I could.
Thank you very much. I'm going to call my presentation Duty of Care in Granting Environmental Authorization, but I'm not going to start. We've changed the order a bit, and Catherine's going to start. I'm going to go second, followed by John Rantlo, and then Angela Vunderberg. So now let me get out of here and stop sharing. And Catherine's on. I'm going to introduce Catherine. Catherine Warburton has been the Managing Director of Warburton Attorneys, Inc. and Imbewu Sustainability Legal Specialists for more than 20 years. She was admitted as an attorney in 1996 and has worked in the field of environmental law for the past 25 years. She's completed her BA, LLB, and LLM at the University of the Witwatersrand. Her LLM dissertation evaluated South African EIA processes in the context of the public-private partnership projects, with the Gauteng project as the case study. She has worked on many infrastructure development and mining projects and has expertise in climate change and other sustainability issues. Very pleased to introduce Catherine to take our first slot, and we're going to try and keep each of our talks to about 12 minutes, and I'll give a time warning. Thank you. Catherine, over to you.
Thank you so much, Peter, and good afternoon, everyone. Peter, can you see my screen? Did I successfully share? Okay, excellent. Great. Well, I have the privilege of kickstarting our discussion today, and we have 2 international cases and 2 South African cases. And so the first case that I'll be presenting is at one of the international cases, and I'm sure most of you will already have heard about it and read of it. It's quite a landmark and groundbreaking decision from the Hague District Court. The judgment was handed down on the 26th of May of this year, and there were a number of applicants. Most of all, well, I'm just looking at the list of them, they were all public interest or not-for-profit organizations. And we are now commonly referring to the judgment with the reference to the first applicant, Milieudefensie versus Royal Dutch Shell. And the crux of the matter was that Royal Dutch Shell was ordered to reduce its greenhouse gas emissions by 45% by 2030 relative to 2019 emissions across all activities, including both its own emissions and end-use emissions. And the reason we've included this case in our panel discussion today is because the judgment pivots around the duty of care. So the duty of care principle was used to found liability in this particular case. And that's, of course, the topic of our panel discussion. So if one looks at the wording of the actual court order, Royal Dutch Shell was ordered to, both directly and via companies and legal entities it commonly includes in its consolidated annual accounts, and with which it jointly forms the Shell Group, to limit or cause to be limited the aggregate annual volume of all CO2 emissions into the atmosphere. And that includes both scope 1, 2, and 3 emissions due to the business operations and sold energy carrying products of the Shell Group to such an extent that this volume will have reduced by at least net 45% at end 2030 relative to 2019 levels. So there's quite a bit to unpack there. And I think the first important thing is that this judgment applies to the whole Shell group. And the Shell group is comprised of over 1,100 separate companies based all over the world. So that's the first really critical issue, and that's why the title of my presentation refers to the judgment reverberating across the globe. So you would have companies based in Asia, in Africa, that would all now suddenly be required to comply with this judgment emanating from the Netherlands. Then the second very noteworthy part of the judgment is that it applies to scope 1, 2, and 3 emissions. Scope 1 emissions are direct emissions from sources owned or controlled by Shell. Scope 2 emissions are indirect emissions from third-party sources from which Shell has purchased electricity and heating, for example, for its own operations. And then scope 3 emissions are other indirect emissions resulting from the activities of Royal Dutch Shell, but which occur from greenhouse gas sources owned or controlled by third parties or organizations. So that would include emissions from third-party use of Royal Dutch Shell products. So that gives an indication of the enormous scope of application of this judgment. Another interesting aspect of the judgment is that it includes extremely useful summaries on these various issues that I've just summarized in the slide. So for those of you who might have become a bit rusty on some of the scientific issues around climate change and its consequences, or alternatively, some of the assessment reports. Of course, this judgment preceded the 6th assessment report, which was released in August of this year. But the judgment does delve into the 4th and 5th IPCC assessment reports and the reasons for concern around climate change. It also sets out the projected impacts of climate change with a particular focus on Europe and the Netherlands, and then deals also with the conventions, international agreements, and various policy interventions around climate change, including the UNFCCC, the IPCC, UNEP, the Paris Agreement, most importantly, and you'll see why and how that is linked to the duty of care finding in the judgment, the IEA, UN guiding principles, and then what I think would be of key interest to corporate entities would be the extent to which the judgment unpacks the arrangement or the organization of the Shell group of companies, its impacts, and also its policies and plans. It looks at the Shell website, it looks at its annual reports, its sustainability reports, its HSSE and climate change policies. So it's really a reminder of the extreme importance of these documents and what companies commit to, what they undertake to do, and then also their sustainability reports on the impacts that its operations are having globally and not only in a domestic jurisdiction. So after giving a very useful and detailed exposition on all of those issues, the court finds that the Royal Dutch Shell reduction obligation emanates from the unwritten standard of care laid down in Book 6, Section 162 of the Dutch Civil Code. And the judgment states that acting in conflict with what is generally accepted according to unwritten law is unlawful. So in the Netherlands, the duty of care is in fact an unwritten duty of care. And that immediately brings to mind our very clear statutory duties of care in both Section 28 of NEMA and Section 19 of the National Water Act. And then, of course, there are also duties of care in the National Waste Act and our Coastal Management Act. And one then thinks, well, if such an important finding is based on an unwritten duty of care, one, how did the court arrive at such a conclusion? And then two, how much easier would it be to found this kind of liability in a jurisdiction like South Africa, where we have clear written statutory duties of care in our law? So the court went on to state that when determining corporate policy, the duty of care exercised in society must be observed, and business enterprises must respect human rights. So there's this, in the European courts, often a linking back to the importance of human rights in jurisdictions where they don't necessarily have the same kind of constitutional rights that we have to, or constitutional environmental rights entrenched. And there is generally a greater focus on human rights. The interpretation of the duty of care requires an assessment of all of the circumstances of the case in question. And the court found that the Paris Agreement goals are non-binding, but represent a universally endorsed standard to prevent climate change and protect common interest. So the court recognized that not only are the Paris Agreement goals non-binding on signatory states, but they would obviously automatically then be non-binding on corporate entities. But it still found that they were essentially binding on Shell, Royal Dutch Shell, through the duty of care principle, and because the goals represent a universally endorsed standard to prevent climate change. So it's really a very groundbreaking decision. The court made its decision provisionally enforceable, meaning that Shell will be required to meet its reduction obligations, even if the case were to be appealed. And of course, Shell did confirm in July 2021 that it will appeal the ruling issued by the district court. And it remains to be seen, of course, whether the ruling will be upheld on appeal.
1 minute, Catherine.
On its website, Shell indicated that it aims to rise to the challenge of the ruling and accelerate its powering progress strategy to become a net zero emissions energy business by 2050. But the grounds of appeal, at least as indicated on the website, are that Shell feels that, it seems from the website, that what is needed is clear, ambitious policies that will drive fundamental change across the whole energy system, but that it's a challenge that requires urgent action and an approach that is global, collaborative, and encourages coordination between all parties. So even the court found that it remains to be seen whether other companies will substitute Shell production in the face of Paris Agreement obligations, and noted that the causal relationship between production limitation and emissions reduction. The courts also acknowledged that Royal Dutch Shell cannot solve this global problem on its own. However, it was held that this does not absolve Royal Dutch Shell of its individual partial responsibility to do its part regarding the emissions of the Shell Group, which it can control and influence. So one of the issues that I was hoping might come up in discussion would be perhaps competition issues that may flow from this judgment, where you have production limitations on the Shell Group, which might not be applicable to other petroleum companies, and how that might play out on the global platform in terms of substitution of production, and whether this might then actually result in a net reduction of emissions from the petroleum industry overall. So I'm hoping that we can discuss that in our discussion session, and thank you so much for the opportunity. Back over to you, Peter.
Thank you so much, Catherine. If you could get out of share screen, and I'll try and share mine.
Here we go.
Thank you. Thanks very much for that, Kath. We will save questions and comments till after all of us have presented. It really was a groundbreaking case, and yeah, I really look forward to that discussion. Thank you. So this is the title of mine, the Sharma by her litigation representative sister Marie Brigid Arthur versus the Minister
Peter,
for the...
we do not see your screen, sorry.
You can't, okay. Let me try again. Share screen. Ah, all right. My bad. Thank you. Let's try that again.
Just on presenter mode, and it's fine. From the beginning, yes.
All right. Thank you so much. All right. That's there's the citation of my case. I will post a link to the judgment in the chat. The second respondent in the case was Vickery Coal, who applied to extend a coal mine in New South Wales, Australia. And the decision whether to approve it or not was before the Minister for the Environment when the application was brought. The relevant department and the New South Wales Independent Planning Commission had recommended approval after finding that the possible adverse environmental impacts associated with the extension project were outweighed by the public interest in granting its approval. Sounds familiar. Sister Arthur represented 8 Australian children and all children residing in Australia, and sought an injunction, in our law, an application for declaratory relief and an interdict, an injunction against the Minister that she owes them a duty of care when deciding whether to approve the coal mine extension. They asked for an order precluding the Minister from breaching her duty of care when taking the decision. This, of course, is the future generation litigating to protect itself. Australian law. In Australian law, the existence of the duty of care is a necessary condition of liability for negligence, which focuses upon the foreseeability of harm and the relationship between the person who has caused or contributed to the harm, or will do so, and the persons who have or may be harmed. It requires a multifactorial assessment in which at least 17 salient features relevant to the appropriateness of imputing a legal duty upon the putative tortfeasor are assessed and weighed. When the duty of care concerns the exercise of a statutory power, it turns on a close examination of the terms, scope, and purpose of the relevant statutory regime. The 156-page judgment contains a record of very detailed evidence and analysis by the court. Much of it was factual evidence, and it was not disputed. Risk of harm was analysed under the following headings: the effect of the greenhouse gases upon the Earth's surface temperature, the Earth system, carbon sinks, feedbacks, the tipping cascade and hothouse Earth, Effects to date are human emissions of CO2, future effects, that is, future world scenarios of a 2, 3, and 4 degrees Celsius future world, and what needs to be done to achieve a 2-degree future world. Note that we are already above the 1.5 of the Paris Accord. It is expected that over the 25-year life of this project, an additional 33 million tons of coal will be extracted from Vickery's coal mine. This would in turn cause 100 million tons of CO2 to be emitted when that coal is burned. The minister accepted that, one, the Earth's surface temperature is increasing and that humans are primarily responsible. Two, average surface temperatures will likely continue to increase and Australia will experience more drought, sea level rises, and extremes of heat, rainfall, and fire-related weather. Three, increases in temperature affect the environment, the economy, and society. Four, the climate exacerbates inherent risks and introduces new risks in the context of heat waves, droughts, bushfires, floods, and tropical cyclones, all being part of the Australian climate experience. Fifthly, the projected effects of climate change depend upon the extent of greenhouse gases emitted globally in coming years. The court accepted that the best available outcome that climate change mitigation measures can now achieve is a stabilized global average surface temperature of 2 degrees above pre-industrial levels. However, at that temperature and beyond, there is an exponentially increasing risk of the Earth being propelled into an irreversible 4-degree C trajectory because of Earth system changes. The applicants presented unchallenged scientific evidence on the future trajectory of global average surface temperatures. The evidence was largely based on the climate change modeling of the IPCC. This is up to the 5th report. We've seen now the 6th one. And more recent assessments made by Professor William Stephan, an eminent specialist in climate science. The following plausible propositions were demonstrated in that evidence. Sorry, let's just go back. The best future stabilized global average surface temperature, which can realistically be contemplated today, is 2 degrees above pre-industrial level. This presents a risk ranging from very small at about 2 degrees to very substantial at about 3, that the Earth's natural systems will propel global surface temperatures into an irreversible 4 degrees C trajectory to reach there by about 2100. The 100 million extra tons of CO2 is likely to cause a tiny but measurable 1/18,000th of a degree Celsius increase to global average surface temperatures. In doing so, it would increase the risk of global average surface temperatures increasing beyond 2 degrees and the risk of global surface temperatures being propelled to an irreversible 4-degree trajectory. In the court's assessment, this risk is real, meaning that it may be remote, but it's not far-fetched or fanciful. The risk of harm to the children from climatic hazards brought about by increased global average surface temperatures is on a continuum in which both the degree of risk and the magnitude of the potential harm increases exponentially if the Earth moves beyond 2 degrees towards 3 and into 4 above pre-industrial levels. Other expert evidence concluded that over 90% of Australia's existing viable coal reserves cannot be burnt in order to be consistent with a 2-degree temperature target. The minister's defense focused on the inappropriateness of the common law intervention into policy-based statutory risk. The court found that the nature and extent of the harm that may be experienced by the children may fairly be described as catastrophic, particularly should the global average surface temperatures rise to and exceed 3 degrees beyond pre-industrial level. The evidence demonstrated that a reasonable person in the position of the minister would foresee harm. Each of the children is exposed to a risk of death or other personal injury. The court considered the law in detail. There's no time to go into in detail today. Justice Bromberg found that the minister does have a duty to take reasonable care to avoid causing Australian children personal injury or death arising from emissions of carbon dioxide into the Earth's atmosphere, while determining, excuse me, whether or not to approve the project. In doing so, His Honour characterised the harm of climate change as the greatest intergenerational justice ever inflicted by one generation of humans upon the next. The type of harm that the applicants assert the duty should cover is mental or physical injury, including ill health or death, as well as damage to property and economic loss. Referring to the 3 and 4 degree scenarios, the court stated at paragraph 293, and I want to read this. It's difficult to characterize in a single phrase the devastation that the plausible evidence presented in this proceeding forecasts for the children. As Australian adults know their country, Australia will be lost and the world as we know it gone as well. The physical environment will be harsher, far more extreme and devastatingly brutal when angry. As for the human experience, quality of life, opportunities to partake in nature's treasures, the capacity to grow and prosper, all will be greatly diminished. Lives will be cut short. Trauma will be far more common, and good health harder to hold and maintain. None of this will be the fault of nature itself. It will largely be inflicted by the inaction of this generation of adults in what might fairly be described as the greatest intergenerational injustice ever inflicted by one generation of humans upon the next. This judgment follows the path-breaking Urgenda and Shell decisions in the Netherlands, which found, as Catherine has said, a climate-related duty of care in Dutch law. There are reportedly hundreds of climate change cases in process around the world. Other aspects of the case that resonate with our law include the precautionary principle, intergenerational equity, health and well-being, and of course, sustainable development. However, having declared that there is a common law duty of care on the environment in the exercise of its statutory decision-making power, the court declined to give the injunction, as that would pre-decide the issue for the minister. The minister now has to make that decision, knowing that there is a duty of care that should not be breached. The strong expectation is that this decision will be appealed by the minister to the full federal court and possibly to the Australian High Court, which will determine whether this new duty will form part of Australian common law in the future.
1 minute, Peter, but
thank you. Perfect. SA law of delict. It's not unthinkable that the South African law of delict could apply to the award of an environmental authorization in appropriate circumstances. But all the requirements of delict would need to be approved, and those are them. Now, this could be the direction in which the law is starting to move, but can we sue the state for its decision? Well, in terms of the State Liability Act, we can. Any claim against the state which could, if that claim has risen against a person, shall be cognizable by the court. And it's any wrong committed by any servant of the state acting in that would be his or her capacity within the scope of his authority. What about indemnity? Section 49 does have an indemnity, 49 of NEMA. It limits the liability of the state unless the exercise of the power or performance of the duty was unlawful, negligent, or in bad faith. Well, those are the requirements of delict. It does not preclude, in my assessment, a delictual damages action. Let's turn to section 28 of NEMA. The duty of care in section 28 of NEMA is a form of strict liability. That means proof of fault and wrongfulness are not required. One only has to prove past or future causation of significant pollution or degradation of the environment by the person one is seeking to hold liable, and a failure to take reasonable measures. The action would be against the polluter, the owner, or the possessor of the property, not the state. Now, the decisions of the competent authority and the minister. The duty of care does seem relevant to a risk analysis and to the minister's decision on an environmental authorization. Risk analysis is an integral part of the EIA in terms of NEMA, part of the foreseeability test in negligence, and part of the duty of care in section 28 of NEMA. So the case I've discussed indicates that an analysis of the risks associated with approving a new coal mine would show that the extent of the risk of personal injury arising from the result of climate change is very high, and it's scarcely able to be mitigated. This would appear to be a very significant factor that should be taken into consideration by the competent authority when considering whether or not to approve an EA for coal mining. In closing, placing all the relevant information before the Minister is therefore essential, and a failure to do so would render the EA reviewable in terms of PAGIA. The question of state liability in delict for breaching a duty of care to prevent climate change when authorizing activities with GHG emissions poses itself as a question for our future. All right, let me see if I can get out of here. Am I still sharing?
Yes, Peter, you're still sharing.
All right, stop share. Thank you, John. All right. I'm now going to hand over to TSETSO John Rantlo. John is the ELA EXCO member representing Northwest Branch and a temporary lecturer at the Northwest University Potchefstroom campus at Northwest University. Dr. Rantlo recently completed his doctorate with the Northwest University, which focused on the environmental authorisations in South Africa. Over to you, John.
Thank you so much, Peter, and greetings once again, ladies and gentlemen. So I'll try to keep my presentation today as brief as possible. So today, as my previous colleagues have discussed, I will also be talking about the duty of care and environmental authorizations, just drawing lessons from the Tendele coal mining judgments, both the High Court and the Supreme Court of Appeal judgment. So in my discussion, I will briefly do the introduction and then discuss the cases. And under the cases, I'll highlight a few issues that are relevant to my discussion, the facts, the High Court judgment, the Supreme Court of Appeal judgment, which I'll touch on the majority judgment and briefly on the minority judgment, and I'll do a brief discussion and concluding remarks. So I think it's a common cause that the mining has a significant impact on the economic growth, job creation, improvement of the infrastructure, and so on and so forth. At the same time, mining activities have adverse impact on the environment, which can influence food security, health, the well-being of the people, so on and so forth. Thus, mining activities must be regulated. And this at times requires that certain mining activities be operated or conducted subject to environmental authorizations. So South African mining law has been riddled with challenges in relation to environmental authorizations. And this can be, it's evident in this case that I'll be discussing in the recent Ezulweni judgment that has been before the courts recently. The Section 28, which provides for the duty of care, may be useful to address some of these challenges that have been witnessed resulting from our legislation. So in this paper, or in this presentation, I argue that the court took a step in the right direction in suggesting the duty of care in Section 28 of NEMA as an alternative tool, where the parties in a dispute allege that illicit activities are carried out without environmental authorizations. And this is where my presentation slightly differ with my other colleagues, because it deals with instances where the supposedly illicit activities were carried out without environmental authorizations. And I'll argue further that more tools, however, will need to be used to supplement the duty of care under Section 28. So the Supreme Court recently handed down a judgment in the Global Environmental Trust and others versus Tendele coal mining. the appellants who were applicants in the High Court sought an interdict against Tendele from continuing with the mining operations. So there were several issues in that particular case. The first issue related to the fact that Tendele had no environmental authorization in terms of Section 24 of NEMA, and it had no land use authority approval or permission. It had no waste management license, and that it had no written approval in terms of Section 35 of the KwaZulu-Natal Heritage Act to damage, alter, exhume, or remove any traditional graves from the original position. But however, for the purposes of today's presentation, I'll only focus on one of the issues which related to whether Tendele was required to obtain environmental authorization, and if so, whether continuation of mining operation was permitted pending the compliance, and whether EMP obtained under the MPRDA prior to the 2014 or the coming into effect of one environmental system entitles Tendele to continue with its pre-existing operations. So just a brief background and the facts. Tendele mining operation commenced in 2006 pursuant to the mining right and the approved environmental management program, or the EMP, under MPRDA. So the mine comprises a single mining area. But however, the mining operations are divided between 5 areas, and separate mining rights and separate EMPs apply to the different areas. So the Tendele is actively mining, or at the time of the hearing of this case, so Tendele was actively mining in Area 1 and extended area of Area 2, namely the KwaKubuka and Luhlanga areas. And the mines coal wash plant are located in area 2. So in the High Court, the applicants, they argued that the Tendele had no environmental authorization issued in terms of Section 24(2) of NEMA to conduct mining operation, amongst others. And then in return, Tendele argued that the mining operations were undertaken or are undertaken in terms of a valid mining rights and EMPs under the MPRDA, and it did not require environmental authorization and the NEMA. And then the court did go extensively in discussing the legislative requirements in this regard, whether Tendele required environmental authorization in terms of NEMA. But in the interest of time, I will not really go into the reasoning of the court. But however, suffice to say that the High Court dismissed the application, and it stated that the applicants failed to establish a proper course of action, that they did not identify precisely the listed activities undertaken by Tendele without the necessary environmental authorizations. The EMP under MPRDA has effect of the environmental authorization under NEMA with respect to the fact of this particular case. And then the applicants had failed to establish or make case for an interdict. And I must highlight that it was not clear from the onset whether the applicant sought an interim interdict or final interdict or structured interdict. But however, as the case proceeded, it turned out that they were actually looking for an interim interdict. So the court further held that the applicants could have used alternative remedies to resolve their issues, such as Section 28 of NEMA, which is duty of care. And this is where my interest is, or the part that captivated me in this judgment. So the duty of care, with regards to duty of care in Section 28, the court indicated that applicants could have approached the court in terms of Section 28(12) of NEMA to ask the court to direct the Director General or the provincial head of department to take the steps that are set out in Section 28(4) of NEMA. And briefly, Section 28(4), it provides that the DG or the HOD, after consulting with any other organ of state concerned and after having given adequate opportunity to affected persons to inform him or her or their relevant interests, may direct any person who fails to take the measures required under subsection 1 to investigate, evaluate, and assess the impact of specific activities and report thereon, to commence taking specific reasonable measures before a given date, diligently continue with those measures, and complete them before a specified reasonable time. So in a nutshell, that's what Section 28.4 provides. But then the applicants did not make use of the remedial measures to engage meaningfully with the relevant authorities. And this perception of the court, or this reasoning of the court, it ties so well with the views that was advanced by Professor Milieudefensie in her paper, where she discussed the case of K Produce and others versus, or trading as pelled products versus others, where she was making an argument about the use of advocacy tools, which include developing professional relationships with the officials. So in her argument, some of the things that she highlights is that the courts should preferably only be used as a last resort unless there is a reason to believe that a court will play an activist role in environmental matters. So if a matter dealing with the pollution is put before the court, it is important to prove pollution by way of admissible evidence, including expert evidence under oath. And in this particular case, one of the challenges that the applicants made was to actually prove that the listed activities that were carried out, that they were alleging had been carried out, were really listed, and that is why the case was dismissed, because their pleadings they made the bad pleadings. So the Professor Milieudefensie further continues to argue that the courts tend to be conservative in their interpretation of the law, meaning that it might be easier to use other advocacy tools. It will also be helpful to develop a close but a professional relationship with the use of officials. So this is what I believe, that, you know, when the court says applicants did not make use of these remedial measures, ties so well with the views of Professor Milieudefensie in this regard. So with regards to the Supreme Court of Appeal judgment, the majority judgment believed that the leave of appeal should have not been granted from the onset, and it indicated, also agreed with the High Court judgment, that the appellants did not have a cause of action because of the bad pleadings. They failed to allege that Tendele contravened Section 24F. And the pleadings did not identify the listed activities that were commenced without environmental authorizations. And further, that the case did not raise any interpretation issues. But however, the minority judgment found that, or it noted that the Tendele did not deny that it carried out listed activities, that Tendele had a course of actions contrary to what High Court and the majority judgment of the Supreme Court of Appeal found, and that the EMP under the MPRD, it's not the same as environmental authorization under NEMA, and that Tendele ought to have obtained environmental authorization under NEMA. Therefore, Tendele's mining operations are unconstitutional. They are unconstitutional.
1 minute, John.
Oh my goodness. Okay, thanks, Peter. So with regards to the duty of care, so the High Court noted that, as I indicated, that there are other measures, remedies, such as duty of care, which is in Section 28 of NEMA, that could be explored as alternative to stopping or halting development, where it is alleged that environmental authorization was not issued. And as I indicated, those would have required that there should be assessment, there should be reporting that should have been done. So in a nutshell, Section 28 provides for a duty of care. So according to Professor Milieudefensie, again, who happens to be my supervisor, the duty of care in Section 28 of NEMA is an embodiment of the precautionary principle, and that the negative impact should be anticipated, and where they cannot be altogether be prevented, they must be minimized and remedied. Further, the duty of care includes optimization of actions and process to prevent pollution, or where it cannot be prevented altogether, to reduce it to acceptable levels, further by doing an EIA. So the information obtained from EIA should be used to seize, to modify or control an action or process that causes pollution, or to eliminate or reduce the sources of pollution or degradation. So it must be borne in mind in this regard that the assessment and the reports required under Section 28 must be distinguished from assessment that is required under Section 24 of NEMA, where EIA must be carried out before the development is granted. So, and one thing that also comes up from this judgment is that not only do the competent authorities must consider Section 28 in decision making, but also it brings forth the issue that, or the idea that the interested and affected parties as well, they must consider it where dispute arises. So some of the
you wrap up, please, Joe.
Okay, Peter. So Section 28 would have not necessarily, one of the challenges that I pick up from this judgment is that although the court made reference of Section 28 of NEMA, it would have not necessarily enabled Tendele to obtain environmental authorization. Therefore, this calls for such other instruments as Section 24G of NEMA, where the Tendele would have had to apply for retrospective environmental authorization. In fact, the Supreme Court of Appeal brought this issue up in its ruling, which, but however, remains a minority judgment, where it suggested that the Tendele should actually follow the Section 24G of NEMA, albeit not in express terms. So in conclusion, the interpretation challenges emanating from NEMA and MPRD still persist, but however, the court took a step in the right direction in recognizing that Section 28 or duty of care can be used as an alternative tool where environmental authorization was not obtained, as opposed to approaching the court right away to ask for interdicts. I'll end there, Peter.
Thank you very much. That's a very insightful presentation, and just shows how court cases can go wrong. But it does highlight some real issues for litigation and also the way ahead. Dr. Angela Vunderberg is next. Angela is the acting director of the newly established Global Environmental Law Centre, GELC, at the University of the Western Cape, Faculty of Law. She holds this position with the position of senior lecturer in the Department of Public Law and Jurisprudence, where she runs and teaches in the LLM Masters in Environmental Law. Her research expertise includes climate law and governments, urban law, planning law, and environmental law. So I'm very pleased to hand over to you. Thank you, Angela.
Thank you, Peter. I am going to share my screen. Can everyone see the screen?
Yes.
Yes, Angela.
Perfect. All right, thank you. Yes, I am going to speak about the Khanyisa coal power station case, and I'm going to try and draw some links between this case and some of the other cases discussed as it relates to the duty of care. So just a bit of background, this is something we all know. We know that electricity production and coal is inextricably linked to climate change. And of course, it accounts for a significant amount of our global emissions. And South Africa really is heavily reliant on coal to provide our electricity. And this is not necessarily going to change within the next 2 decades. So we can safely say that coal-fired stations are not going to go away anytime soon. And South Africa's 2019 Integrated Resource Plan actually makes provision under the coal-based IPP program for independent power producers to request approval or offer tenders to establish such stations. But fortunately, we do have Section 28 of NEMA, which establishes that general duty of care on every person to avoid pollution and environmental degradation. And this duty really does apply equally to decision makers, so the government officials, whether it's the minister or whether it's a department granting an environmental authorization, but also to the applicant or the IPP who may cause harm to the environment. So I'm going to look at this case. It went on appeal and review in the High Court, and it also moved to the Water Tribunal. But before I do so, just some background. So Aqua Power in this instance was appointed as the preferred IPP to establish the Khanyisa coal power station. And they obtained their environmental authorization in 2013 to operate a 450 megawatt station. And later the authorization was amended to upgrade the power station to a 600 megawatt. And it attracted quite a lot of talk because Khanyisa would have been developed in the high felt priority area. And this area already includes 12 power stations polluting the air and water in the area. And this has to be taken into consideration with South Africa's commitments in terms of its NDC under the Paris Agreement. We have to reach certain targets that will allow us to reach our peak plateau decline trajectory. And the Khanyisa project is estimated to increase our emissions. And that was even considered at 450 megawatts, never mind the upgrade to 600 megawatts. Something else that was controversial is that the station would remain in existence for 50 years. And that is really far beyond what the South African government committed to reduce in terms of its emissions in absolute terms. So one has to question why then would the department grant these environmental authorizations if it had to keep its Paris Agreement commitments in mind. So based on the severity of the air pollution, the estimated greenhouse gases, and the potential water pollution in the area, Groundwork and Center for Environmental Rights approached the High Court to have the environmental authorization that was also linked to an EIA reviewed and set aside, and approached the Water Tribunal to appeal the decision to grant the water use license. In the High Court, it was argued that the minister really granted the environmental authorization and the amended one without proper assessment of the impact of climate change of this project. It was also raised that in its environmental impact assessment that is attached to the authorization, Aqua Power failed to provide a full and detailed assessment of the emissions over the life cycle of the project. There was no assessment on the increase of emissions in the increasing capacity of the station. There was no assessment of the aggravated effects of climate change in the high felt priority area, or how it would affect water scarcity in the region. And the EIA also did not include any assessments on avoiding, mitigating, or remediating the effects of climate change. So a few years passed because there was internal reviews, but eventually in 2020, the court referenced the Tambisi judgment of 2017, which makes it clear that for the first time in our law, the impacts of climate change for coal-based power stations must be thoroughly assessed and considered before an environmental authorization can be granted. And it was explicitly stated that Aqua Power's poor assessment of climate risk and the minister's granting of the environmental authorization resulted in a gross underestimation of greenhouse gas emissions for the long term as well. The court also noted that the original and the amended environmental authorization had actually lapsed, so Aqua Power was operating, illegally or without the proper authorization, so they could not continue. In the Water Tribunal, it was argued that the decision to authorize the water use license violated the right to dignity, the right to life, and the environmental right. And particularly, it was highlighted that the project would result in unacceptable pollution of water resources. And here, finally, they mentioned duty of care. Section 19 of the National Water Act and Section 28 of NEMA creates a duty of care on ministers and government departments to really prevent environmental degradation. And this duty should be considered when they make decisions to authorize permits. It was also submitted that the government holds water, specifically in a public trust, and that it should thoroughly consider the impacts of climate change or mining activities and climate change on water resources, and that based on these submissions alone, the water use license should have been denied. So in 2021, the Water Tribunal actually set aside the water use license, saying that the Department of Water Services failed to conduct an adequate public participation. So the ruling then confirmed for the first time, at least in the context of water governance, that climate change is a legal requirement and it must be considered when deciding to grant a water use license. It also acknowledged that the Department of Water and Sanitation failed to properly consider the climate change impacts, and that if it had properly considered, it would have concluded that the project would not be a beneficial use for the public interest of water. So here, the Water Tribunal sort of alluded to the public trust doctrine, but it didn't really go into the duty of care, and that is unfortunate, considering that the duty of care was one of the principles that was argued in front of the court. So the Water Tribunal rather focused on a lack of public participation and a violation of Section 24 in the Constitution. And I do think this is a missed opportunity. It would have been great to see the tribunal linking the duty of care principle maybe to the public trust and giving us just a stronger interpretation in that context. Also with regard to government responsibilities for climate change and the impacts of water use licenses for mining activities. Nevertheless, we can say that both the High Court and the Water Tribunal did acknowledge, specifically mentioned gross misconduct of government departments in granting the respective licenses. And while none of these sort of submissions by the courts were linked to holding the ministers accountable or linked explicitly to duty of care, we can say that the ministers and the departments did receive sort of a slap on the wrist for approving the various authorizations. So this is in contrast to the Australian case that Peter discussed earlier, where it was decided that, you know, at a minimum, the minister should have foreseen and could in fact perhaps be held liable. But we do hope that this movement is recognized, at least in South Africa, and that we can move towards holding our ministers and departments liable and having a stronger implementation of these environmental principles. And then, of course, we have the Tendele case, which was also discussed earlier, where at least the duty of care principle came to the forefront of the discussion, even though it didn't happen necessarily in the Water Tribunal. So I do want to stress, though, that the Khanyisa case is a win for the environment. The applicants did succeed in their review in the High Court, and the tribunal did also take away the water use license, and there are now stricter requirements for granting an environmental authorization and a water use license. And, you know, in fact, stopping this case, the power station, which it has halted all operations, means that almost 76 million tons of greenhouse gas emissions will not be emitted. Significant air and water pollution in a high flood priority area is going to be stopped. And the South African public has been spared an unnecessary expenditure of almost 7 billion rand for something that is going to cost far more. So it is a win for the environment, and I'm going to end there. Thank you very much.
Thank you so much, Angela. And you won us a bit of time back. All right. Well, look, we now have a few questions and comments that I'm going to put to the panel. And please also feel free to raise your hands if you wish to ask a question live or post it in the chat. So the floor is now open for the panel, and we have two questions put to Catherine. First, from Sue George: how could Shell influence its end users as a result of this judgment? And from a good question from Barry Wisner about a carbon footprint assessment as a requirement of EIA. What do you think about those ideas, Catherine? Could I ask the camera? Please put your cameras on, if you would.
Okay, sure. You might not agree with that. Let me see. how that goes. There we go. So thanks so much for the questions. I think many petroleum companies are, of course, considering this very issue and are moving in a direction where they are offering other energy alternatives to customers. Looking at, for example, providing connection points for electric vehicles at their outlets. So that would be a way that they could reduce the emissions of their customers. What the court did note is that, of course, the easiest and quickest way to reduce emissions is to simply limit production. But it also noted that there would be other players that would step into those gaps in the market. So although there are obviously ways to be very proactive about limiting emissions, there are certain emissions or customers that wouldn't necessarily be able to switch to alternative energy sources, or at least not in the short term. And so one can conceive of the complexity and difficulties that may be involved in that. And then I think the question from Barry, I think that's very much the kind of issue, the carbon footprinting that the court was referring to in cases like Thabametsi and Khanyisa, rather, where it really is important to factor those climate change impacts into the applications for authorization in the first place. And of course, with companies like Shell, one would look at their reports in the sustainability reports on carbon footprint. And that's really what the judge looked at in that case, to say, by reducing Shell's emissions according to their reports of their carbon footprint, how would that facilitate the achievement of the Paris Agreement goals? So that's obviously a key issue in all of these climate cases.
That's a very good point. Thanks, Catherine. I mean, it's certainly now we know we've got to check out the greenhouse gas emissions and carbon footprints for coal-fired power stations and possibly for coal mines. But Barry's question goes wider. It says, you know, should we have a carbon footprint assessment for every application for environmental authorization? Does anyone have any comments on that? I'd raise it as a question. I don't know the answer. I was very interested. There's from Professor Michael Kidd. John, I'll read the question. John, it occurred to me that the facts presented in the Tendele judgment suggested that there were impacts that were probably regulated by their EMP, brackets, and that they were probably not complying with the EMP, close, but this would not have been a better avenue for the applicants to pursue, that they were not in compliance with their EMP. I fully agree with the judgment that the court cannot be expected to divine the non-compliance with the EIA regime from the allegations that don't specify what the provisions were that were not complied with. Do you have a comment? You're on mute.
Yes, Peter. I do agree with Prof. Kidd that perhaps they could have gone via the route of indicating that the applicants were not the applicants rather, but Tendele was not complying with the requirements of EMPR. And I think it goes back to that issue where I indicated that, you know, there are other alternative avenues that they could have used to challenge the activities of Tendele coal mining.
Thank you. And Susanna Coleman has made a very interesting comment there that the PHA campaign, the PHA is the Philippi Horticultural Action, is it? Campaign has had a carbon footprint assessment put together to defend against the EIA already granted, pending appeal. And I'm interested to know how, in what context that will be viewed. How do you know how much carbon is too much? Susanna, do you have a comment on that?
Oh, thank you, Peter, for that. What we're doing is that we are trying to compare what the impact on the environment would be if you kept the land as farmland, especially if you used it for small-scale farmers who would be doing regenerative farming and sinking carbon by using that particular farming method, versus turning the area into a development 10 times the size of Century City. So the carbon emissions from it becoming an urban area versus keeping it as a rural, regeneratively farmed piece of farmland. Thanks.
Thank you very much. Very interesting indeed. One of the things that emerges from Angela's presentation on the Water Tribunal decision is the emergence of the public trust doctrine. Or rather, it's non-emergence. It seems as though the public trust doctrine is essential to the intergenerational right to environmental justice, which just has not been grasped yet by our courts. What do you think, Angela? You're on mute.
Sorry. Can you just repeat that last bit, Peter? I didn't hear it. I think my internet was unstable there.
It seems that the courts are missing an opportunity to make use of the public trust doctrine, which seems to really underpin the intergenerational component of the environmental right.
Yes, I completely agree. I do think, though, that the public trust doctrine should be linked to the duty of care. I would like to see how courts, I know there is a link, but I'd like to see how courts, strongly make that link. And not only intergenerational, but in research I'm doing now at the center on the rights of future generations with regard to climate change. How does duty of care and public trust doctrine apply to those people, the generations that we, in fact, are going to, leave behind when we aren't here? Are our courts, and not even just courts, but are our legal systems geared towards protecting rights for generations that don't exist, and to what extent don't exist yet, future generations, and to what extent are these very core environmental principles relevant in those instances?
Thank you. I see. Thank you, Melanie, for your comment that the court did well in WWF case to link the public trusteeship to intergenerational equity. Does anyone have any comments on whether we should be trying to bring duty of care as a concept into intergenerational equity and public trusteeship? Is this really three strands of the same rope? Does anyone have any comments on that?
Melanie's hand is up.
Oh, sorry, I didn't see. Please go ahead, Melanie. Yes.
I think they're very much three strands of the same rope. And I've written a little bit about it in the context of analyzing the WWF case in relation to rock lobster, and how public trusteeship and intergenerational equity were intertwined in that context. And I think it's also important to, and Linda Collins has written quite a lot about this as well in quite an insightful way. It's important to recognize that South Africa's vision of public trusteeship, unlike elsewhere in the world, is not a private property concept. It's very much a public public law concept or environmental concept where the broader public is part of or in a custodianship relationship with the environment along with the state. I think so what Colin says about your question on is it strings of the same rope, she says, the public trustee doctrine can operate through the courts as a binding domestic mechanism for implementing the international concept of intergenerational equity. And she explains how it justifies enhanced protection for the benefit of present and future generations. And in South Africa, that then extends not just to the state, but to the broader public, given the participatory nature of our democracy. Yeah, I think definitely there's a link between the duty of care, again, because the duty of care is a horizontally applicable obligation, and not just one that's binding on the state. And it's an illustration of the horizontal nature of environmental rights in South Africa, so that lends credence to interlinking these ideas.
Thank you very much, Melanie. The question I have broadly for everyone is, does anyone agree with me that Section 28 of NEMA is underutilized in South Africa? And it's a really powerful weapon. And, you know, there's just, don't see it a lot, although it's not as though they get reported unless they go to court. So maybe it is utilized more than any of us are aware of, certainly that I'm aware of. Maybe people do write the letter to the competent authority, and maybe the competent authority does issue a compliance notice within 30 days. And maybe then things roll out and the rest of us are blissfully unaware of it. It would be really nice to have some kind of reporting system on the stats of Section 28. And just to remind you that, as John correctly pointed out, one's got to get the science right. Before one writes that letter, one has to have one's ducks in a row. You have to do the science first, get the expert data and reports, attach it to your letter and say, as you can see from the attached, the duty of care as a factual matter is being breached. Take steps or else we'll have to take you to court to make you take steps. And that's the mechanism of it. I see Melanie says there's a report from the department for each year. Thank you. I will look at that.
I think you make an excellent point there, Peter, both insofar as the scientific or technical substantiation is concerned. And then, of course, if one does proceed to court, the incredible importance of the papers. Because if you don't make out the correct averments, then you simply won't succeed with your application, despite the most laudable objectives in protection of the environment. I was involved in an urgent application for an interdict last week, where the applicants, I was acting for the respondents, sought to apply the duty of care themselves against a third party with no scientific foundation presented in the papers. And the court found that in fact, the duty of care principle is for the regulatory authorities to enforce. And certainly in the absence of any clear evidence that there was a breach of the duty of care. It was not a remedy that's available to, a third party to actually just raise willy-nilly, so to speak, although it's a very short judgment. It's only 15 pages, and they don't, the judge doesn't unpack the whole application of the duty of care, but he does say that it's available where there's evidence of significant pollution or environmental degradation, and it's there for the regulatory authorities to enforce. So it's an unreported judgment. I'm sure it will make the rounds, but I think your point about that clear scientific evidence, and then of course one's papers being in order is absolutely crucial.
That's fascinating. I really would like to see a copy of that judgment. Philomene Duplessis points out section 28 places the duty on, in a general manner, on anyone. So that might be quite a severe limitation on who can, in fact, enforce it. I need to look at that. All right. It's 1:15. Are there any other comments, questions for the panel? Otherwise, we'll release you until our continuation at 4 p.m. I'd just like to then thank my panel so much for your presentations and participation. It's been a truly enjoyable and a delight. And thank you all for participating. See you later.